Hello,
Okay.
Corey Brettschneider. How are you?
Hi, Glenn. Nice to see you.
Corey Brettschneider, my colleague in political science here at Brown University, and I'm Glenn Loury. Welcome to the Glenn Show, Corey.
Thanks, Glenn. Pleasure to be back. I really enjoyed the last one, and I'm looking forward to this one as well.
Okay, now 2 months ago, more or less, we had a conversation about your book, When the State Speaks, What Should It Say? You, by the way, are a political theorist and a very productive and thoughtful one. And
Thank
you thought you'd do me the favor of reciprocating by discussing some of my work here at bloggingheads.tv with me, which I'm grateful and flattered. And you've looked at some of my writings about race and affirmative action and want to have a conversation. So that's the purpose of our conversation here this afternoon.
Right. And I'm looking forward to it.
Okay, great.
So can I start?
You
switch roles.
No,
I guess.
yeah, exactly. I defer to you, Mr. Professor Brettschneider.
Okay. Professor Loury, pleasure to have you on the Corey Brettschneider Show.
You wish.
So one thing, Glenn, that I noticed in just looking over the writings over a period of time is that there are some themes that I think are consistent. For instance, your empirical and conceptual work on social capital, I think, is always often in the background. But there are differences in your policy positions, at least, about affirmative action. So I thought a first thing for the viewers of the Glenn Show might be to just ask you about the differences between your positions over time. And you were known at one point as an opponent of affirmative action. Now you have at least some, my understanding is that you think some forms of affirmative action at least are defensible. So what is it that defined the positions over time? And if you could say something too about the evolution and why it happened, I thought that might be interesting for us to hear.
Oh, thanks for asking about that. It's true that I would say in the beginning, when I was a student, I graduated college in 1972, Corey, okay? And I got to Northwestern University, Evanston, Illinois, from the south side of Chicago because of affirmative action. I mean, let's just be direct about this. Mm-hmm. The university, Northwestern University, a great institution, sits cheek by jowl with the city of Chicago. Evanston is adjacent to Chicago, on the lakefront, headed toward the upper middle income suburban North Shore of Chicago along Lake Michigan. Mm-hmm. And 1968 saw civil disturbances after Martin Luther King's assassination in Chicago that made everybody sit back and say, what are we going to do? And they reached out. They wanted to enroll more students from the city. I was a junior college student, having dropped out of a technical institute, meandered in life. My girlfriend became pregnant. We married. I became a young father. I'm going to a community college where one of my professors is an alumnus of Northwestern. One of my teachers at the community college, he sees I have talent. He commends me. Okay, enough about me. My main point is 1970, an institution like Northwestern, trying to get kids who have talent. I was capable and perfectly able to benefit from that education. Get them in where they hadn't been in before and doing something extraordinary, like overlooking, in my case, the fact that I was a college dropout with a very checkered transcript. Decent test scores, but had shown that I wasn't, really all that serious about going to college the first time around. They would have never admitted, certainly not admitted with money, such a person, but for the fact that I was an African-American from the south side of Chicago with promise, and they wanted to incorporate. So now, in the beginning, I was for affirmative action in the sense even...
So you were recruited into the... How did that come to be? They came to the school and recruited you?
No. Mr. Andres is his name, Andres, or was his name. I don't know if he's still living. It's been 40 years.
Right.
Was teaching. He was an engineer, trained at Northwestern, worked in industry in the greater Chicago area, retired from his industrial job to giving lectures on calculus at a community college.
Right.
And I was a whiz kid in his class, and he said, this kid could really go someplace. And I gathered Northwestern had reached out to people like him saying, we're looking for kids like this. And so he directed me to the admissions office. I walked in there, and, the rest is history, so to speak. They ended up enrolling me with a scholarship, and I did well at Northwestern. I went on to get my PhD at MIT, et cetera, et cetera. Anyway.
Right. You made them proud without question, I think.
Well, thank you. But I'm just saying I was for affirmative action.
Right.
in those very early years. Now, come through the 70s and into the early 80s, and I became a Reaganite, okay? I mean, this is a long story, and it's not just about affirmative action, but my politics drifted right for a variety of reasons. I became disillusioned with the Democratic Party. I came to think that the post-1960s kind of intellectual and policy dispensation that the left had bequeathed was really intellectually indefensible and didn't respond to the tough problems that we were facing in the inner cities. And you know, it was like nostalgia for a civil rights era that no longer existed, and it was like in denial against the base. So this is a long story about how I became disaffected from the left. But within that was a kind of skepticism about affirmative action. And again, not to make this overly personal or protracted, I get to Harvard. I'm a full professor. I'm the first African American with tenure in the economics department. Okay,
right.
I'm at Harvard. It's 1982. I'm 33 years old.
Right.
All right. Now everybody around the country is saying to themselves, I'm thinking, yeah, but he wouldn't have been there if he hadn't have been black. Okay, and the president of Harvard University, a man at the time called Derek Bach, is running around.
Hadn't you, Glenn, become, just to get the context, I mean, you had become famous for your work already on social capital, I take it, and for the dissertation, your work in mathematical economics.
It had an impact.
Was there discussion about that, even though you had published in all these journals?
Oh, well, see, that's the thing, exactly. So I get to Harvard 6 years after finishing my PhD. Yes, my work had an impact on the profession, and people had noticed it and regarded it as noteworthy. And I did introduce the concept of social capital into the economics literature way back when, and I've been given credit for that by people as diverse as James Coleman, the late great sociologist at the University of Chicago, Robert Putnam, the professor of government at Harvard, whose book Bowling Alone cites me, amongst others, as progenitors of this idea.
Popularized the idea, I think, the Bowling Alone, right? Yeah.
And drew on that idea. It's a phrase, it's an idea, I had something to do with it. And mathematical economics, and I was doing very well in the journals and had top publications in Econometrica, the Review of Economic Studies, the Journal of Political Economy, the American Economic Review, such places. So I was doing well in the profession, and you might have thought, therefore, that I would have been insulated against this, but I didn't. And it may be that at the end of the day, it didn't much affect the real opinions that people had, but I'm saying that my perception was, or my sensitivity was in my personal situation, that I was somehow tainted by affirmative action. So I became skeptical. And then there's the political correctness aspect of it, because during the 80s and into the 90s, it just wasn't acceptable to raise any questions about the efficacy or the legitimacy of affirmative action. I mean, you could say things like, well, maybe we shouldn't be doing it as aggressively as we're doing it. Maybe we're admitting, maybe we're too overly ambitious and we're admitting kids who can't do the way. And, people would go ballistic and they would say that you were a racist and that you weren't committed to the this or the that. And I reacted quite negatively to what I regarded as mild intellectual thuggery around the issue of people who are simply saying, you dare not speak that. What's wrong with you?
We had touched on some of that atmosphere last time when we talked about your piece on political correctness and the atmosphere it created at that period of time in academia.
So I had questions, but we get to the 90s, we get to the battle over Proposition 209 in California, which was the first of the state ballot initiatives that ended up banning affirmative action, and similar initiatives have been adopted in a number of other states, including Washington State, Michigan, although I gather a federal court has recently ruled against the ballot initiative in Michigan, and other states. And I just felt that the absolutist position that affirmative action of any sort in any fashion that takes race into account is unconstitutional, violates the 14th Amendment. I disagreed with that. And so I began to try to fashion what I hoped would be a more nuanced position, which would acknowledge the legitimacy of some kinds of extraordinary efforts to promote racial diversity and African American and Latino participation in elite institutions, but that would still be open to, legitimate criticisms about the effectiveness of this or that program, and could be a part of a normal policy debate rather than being this all or nothing constitutional debate. And that's what I take to be my current position.
Right. That you're worried in particular about the court cutting off the possibility of a diversity of programs emerging that could take race into account. Is that one of the worries? That it sounds like you still are worried about some versions of doing affirmative action, but you're especially worried about the court cutting off the possibility of experiments and how to go about recruiting people and including race as part of that.
I'm worried that the court will make some kind of colorblind ruling in the spirit of the simplistic argument you can't get beyond race while you're still taking race into account, and will declare that the racial classification that's the basis of preferential admissions policy is kind of ipso facto inconsistent with the 14th Amendment. And I don't, I'm not a lawyer, and therefore I may not have a view that that anybody should take seriously here. But I feel that it's a mistake to identify the anti-racism and the equal protection aspects of the 14th Amendment, which are substantive in my mind, not merely procedural. They're not merely about which boxes are on a form. They're about substantive equality of opportunity and standing in the society. To identify that with a blindness notion, a notion that we will not take cognizance of the racial identity of any persons as we determine how it is that people will be treated. Because I think that there are a lot of activities other than direct preferential admissions, which in one way or another are racial in their view, and which I'd hate to see, sort of thrown out baby with the bathwater style by a court that rules in a kind of rigid way against any kind of racial classification.
Now, this might be a nice place to transition to your Du Bois lecture from Harvard that's published as The Anatomy of Racial Inequality that I wanted to ask you about, because I think what it does is that it delves into a lot of the themes that you hear discussed in a surface way in the affirmative action debate and in a deeper way. And so let me just, by way of introducing the book, say something about the frame that you've already mentioned. One reason why affirmative action now is at risk of being struck down by the court as inconsistent with the 14th Amendment is because of a particular philosophy or a particular way of reading the 14th Amendment, specifically the Equal Protection Clause of the 14th Amendment, as colorblind. That's the phrase that's often used, and it's sometimes seen as having its root in the Justice Harlan dissent in Plessy versus Ferguson. But in a series of rulings, the Supreme Court has edged. They have not said that it's unconstitutional to take race into account, but they've said that when race is taken into account, the court is going to apply its test of strict scrutiny, its highest level of skepticism towards the law, and ask for a compelling interest that is narrowly tailored. And so in the Michigan case, as some of your viewers might know, the court struck down an undergraduate admission plan that they thought was too rigid in its account of race, taking into account race as a specific numerical number and a scale, but it upheld as legitimate the law school's diversity program, which was more, they thought, more nuanced and not as numerical or rigid in taking race into account. And one of the rationales that's clearly acceptable according to that the decision in the Michigan case, is taking diversity into account, which you've also mentioned. So let me begin to introduce the book or ask about how the book might enlighten the current jurisprudence in the current cases, and in particular, the court has just heard oral arguments in a case Fisher against the University of Texas, which many people think might be the end of affirmative action. Now, one of the common arguments that's used against affirmative action by colorblind proponents as opposed to color-conscious opponents, those who want to read the 14th Amendment as incompatible with affirmative action, is the argument about stigma, and that, I think, relates to how we open the show. And the stigma argument, I'll give you just a crude version of it. Maybe there's a better version of it, but I think it says one of the problems with affirmative action and with taking race into account is that it stigmatizes those who are admitted into Northwestern or into Michigan undergrad or the law school. And so if we take race into account at all, that hurts. There's a harm to the minorities that benefit supposedly from this program. Now, stigma is a big part of the Du Bois lecture, and it's a central concept that you use in the anatomy of racial inequality. But you use it in a very different way, I'd say, than the colorblind defenders. So do you want to say something about what your idea of stigma is and how it relates to this argument in the affirmative action debate?
Sure. I use stigma and stereotyping as sort of related, though distinct concepts in my argument in that book, The Anatomy of Racial Inequality. Stereotyping, of course, is, in the common sense use of the term, a view that one attributes to every member of a class, which may or may not be more or less true about the class on the average, but needn't be true about any specific individual in the class. But those individuals may nevertheless be stereotyped as being in this way or that way because it's believed that the class is this way or that way. Stigma I think of as different. I think of it as as related to not the particular information that I impute to an individual member of a class, but to the connotations or social meanings, put that in inverted commas if you like, that are associated with membership in a class. Okay, so it is a unwillingness to extend the presumption or benefit of the doubt when I'm thinking about why it is. I give an example here by this unwillingness to extend the benefit of the doubt when I think about why it is that individuals in the class might be doing poorly. A kind of lack of generosity, a not being able to see there but for the grace of God go I, a predilection to repair to individual-based failings as opposed to systemic failings when trying to account for something like the overrepresentation of African Americans in the prisons or their poor performance in academic competitions on the average relative to other groups. A kind of lack of generosity or a subtle bias in the cognitive processes by which one assesses information about the group. So, for example, when the social psychologists do these experiments where they put experimental subjects in a situation where they have to decide quickly at a computer screen whether or not the person represented in an image is carrying a gun or a mobile phone. All right, and they do the experiment, and the person's supposed to push a button, which means to shoot. You're the law enforcement officer if you think they got a gun, and forbear if you think you got a mobile phone. And then they can code the racial characteristics of the figures on the computer screen differently, white or black or whatever, and they can put the subjects in the experiment under time pressure to see how many errors that they make when they have to try to do these things quickly. And they very systematically find in these experiments, and I give this as just one example of stigma, that subjects are more prone to make the mistake of attributing the person viewed on the screen as having a gun when in fact they have a cell phone if the person on the screen is depicted as a black than if they're depicted as a white. The racial perceptions interact with their cognitive functioning, and they literally don't see exactly in the same way based upon whether or not the person is this or that. Okay, now I went through a long explanation to try to give an illustration of what I mean by stigma, but I take it in a very historical view. I mean, I'm making the argument that, well, race is in any society, in a way, a kind of arbitrary social convention. We classify people based on their physical markings on their bodies, but it's not just that we're classifying, it's also that we're carrying meanings, connotations, expectations, predilections, presuppositions, a kind of orientation toward these categories. And in the United States, the African American category is tainted in this historically tainted with the association of slavery, Jim Crow, segregation, racial subordination, second-class citizenship for a century after, segregated neighborhoods, bias in police departments, racial segregation in social intercourse, who marries whom, et cetera, and that this has a present-day consequence.
So what do you say to your...
And if I may, Corey, that's very, very different from what may or may not be true about the effects of an affirmative action program.
Well, that's what I was going to ask you about is, imagine your opponent says to you, opponent specifically on the question of whether the Equal Protection Clause requires color blindness, the view of those who would strike down affirmative action. Imagine I happen to be a defender of affirmative action, but I could imagine somebody hearing that or watching the show and listening and thinking to themselves, look, I agree with everything that he just said, and that's exactly why I'm opposed to affirmative action, because the source of the stigma is at least in part, and let's imagine that they're sophisticated enough to see that it's not the sole cause, but is in part generated now in contemporary society by these programs that stigmatize those who are accepted into universities with a preference for race. I mean, the way I understand their argument is they want to build on something like what you're saying and use it in opposition to affirmative action. So what's the response to that?
Well, what I would say there is these are really empirical determinations that depend on the circumstances in which we talk about using affirmative action.
Right.
In other words, what I'd say there is it would be one thing to talk about, let's say, I wanted there to be more African-American scientists and engineers, let's just say, all right? And I start with, I don't know what, a high school summer camp for kids who are in their sophomore or junior years, beginning to take chemistry or biology or whatever, and money is being put up for that. And I'm especially interested in recruiting African-American and Latino students to come to this camp. So I'm practicing in one way or another some kind of affirmative action. It's not colorblind. Okay, because I'm trying to increase the presence of these people in this discipline. Now, to say that that's not permissible because it violates the 14th Amendment on an argument that turns on stigma would seem to me to be just apples and oranges. I mean, it wouldn't really apply. And it's like, I think it would depend. I could see circumstances in which the stigma argument would be absolutely compelling about why it is that you wouldn't want to use affirmative action. You wouldn't want to give the people who begin with a doubting suspicion about the capabilities of the group ammunition for their doubting belief by putting people who were only marginally qualified into visible positions of responsibility where others, well-being depended upon them discharging the job in an appropriate fashion, and they're falling short.
I don't think there's anybody who thinks that there should be a hiring of unqualified people. I mean, almost always defenders of affirmative action.
Yeah, they always say that.
Baseline.
Yeah, but in practice, it might yet come to that, and I'm sure we could point to examples where indeed it does. I mean, if you admit students to a university in large numbers who are wildly unqualified to matriculate there, and they end up accumulating in classes that are of remedial character, or, then you're sort of creating a fact on that campus that would be. But I don't want to trade in these kinds of, broad-based blanket characterizations.
And isn't also part of your response, I would think, just going back to the book, to say, look, if you turn the stigma argument into is this narrow concern that there is an individual out there that's going to be thought to be inferior because they were the benefit of a preference program, that ignores the real source of stigma, which is slavery and, as you said, the long history of legal apartheid in this country. And, it's not as if this is something that's going to disappear the moment that we get rid of these efforts at remediation. I mean, that to me is one of the main points that I got out of reading the book, is that it's a twisted version of the stigma argument to look at remediation programs and the attempt to reverse stigma by opening up these roles to people who were historically excluded from them. It's a twisted argument to say that those remediation programs that are an attempt to remediate stigma are the cause of stigma. It ignores the history of race in the United States, right? And at least what I get out of the book is the attempt to challenge stigma. We have to have a multifaceted way of doing that. That has to be open to policymakers, and for the court to really shut off those possibilities is a real worry.
I think that is right. I mean, that is that the way I sometimes put it is that, it's one thing to say that the instruments that a government, a state university, an employer might use ought not to be sensitive to race. Okay, it's another thing to say that our objectives in the policies that we formulate ought not to take any cognizance of race.
Right.
So, and what I worry is that blindness becomes indifference. Okay, blindness is we will not attend to race. We will treat everyone without regard to racial identity, and that's made to be the highest normative principle of being blind, of being neutral.
Right.
But it becomes indifference, which is to say, the conversation about policy turns away from a concern to remedy racial inequality by whatever means. See,
Right.
I want to make it that remedying the historic inheritance of racial inequality is a first order ethical imperative for the society, and we're merely talking about the effectiveness and or propriety of alternative ways of responding in the face of that ethical imperative. And that,
Right.
and that among those responses could well be, and I gave an example, a racially preferential program preparing high school students for careers in the sciences, but I could give other examples as well. Maybe things that we call affirmative action, an elite university that determines that
Right.
as part of its response to its mission, its pedagogic and civic mission of educating the elites for a new generation of leadership, that it needs to constitute itself in a representative way, in a way that the
Right.
student body is reflective of the variations of identity, commitment, orientation, outlook, experience in the society, of which racial difference would be one. Not the only one, but it would be one. And to rule that out,
Right.
you see what I'm saying.
I was going to say that sometimes the way that the court speaks is there are, I mean, it's kind of it's an either or, that there was this past rationale that used to be considered of remediation, and now it looks like the court has said that's not a compelling interest, or that can't be one of the points or goals of the and the ends of the program. The end has to be diversity, and so a lot of what you've said just now speaks to that possible diversity rationale and the kind of society that we want to see. But it's always seemed to me, I mean, the remediation looks like it's a backward-looking or past justification, and diversity looks like it's about our goals to the future. But one thing that your remarks in the book, I think, bring out is, look, stigma isn't something that, imagine we got rid of affirmative action. It's not just something that's in the past, it's something that's in the present. It's a way that we tend to often view each other. I wanted to just give you one of the examples and have you react to it that I was just had the pleasure, actually, of attending the Federalist Society National Lawyers Convention, which is a largely conservative audience, but had a real diversity of panelists and an exciting set of panelists. And one of the, to me, best moments of the conference was in a panel on affirmative action, which included 2 civil rights commissioners on either side of this issue, and also Ted Shaw from Columbia Law School.
Yeah.
Shaw, and I want to not quote him, but paraphrase him, he had a really nice way of addressing the stigma argument that I think brings out some of your views. He said to the people in the audience, look, there are some people here who are over 60, and those people were the beneficiaries of a twisted kind of preference program, one that had quotas, ceilings for Jews, and that didn't admit minorities, and that benefited white applicants to college, especially from elite private high schools. And he said, but do any of you feel stigma, or do you feel that there's any stigma directed towards you? Or he also gave the version where people asked about the psychology of those who benefit. He said, do you feel inferior as a result of your benefiting? And of course the answer is no. Nobody even thinks about that. So to me, anyway, what it brought out is that there really isn't a stigma that's attached to any specific preference. The stigma comes from, as you've been saying, the long history of racial inequality in this country.
Right. I'm thinking here of 2 books in particular. Ira Katznelson's When Affirmative Action Was White. When Affirmative Action Was White. Katznelson is a political scientist, historian at Columbia. The book is a history of the New Deal, the GI Bill, the sort of evolution of the American welfare state in the years from 1932, to 1960 or so. And his point there, which is a cousin to the point that Ted Shaw was making, was that there was a time where the formulation of social policy in this country de facto benefited substantially, preferentially, whites over blacks in the formulation of social policy. So take the GI Bill, for instance. To be eligible, you have to serve in the military, but there was discrimination against blacks in the military. So they're underrepresented amongst the people. Or you take amongst the people benefiting from the GI Bill is colorblind in its implementation. You qualify if you had a certain military history, but it's not colorblind in its effect because access to that history was mediated by racially discriminatory mechanisms.
Yeah.
Or he looks to the Southern senators who were key during the 1930s in holding the Democratic coalition together that made the New Deal possible, and notes how they got domestic workers and farm workers excluded from the protections of the minimum wage and hours and unemployment insurance benefits and so forth that were being legislated in those years as a consequence of their desire to keep the African-American dominated working class in the southern states less powerful than they would have been if they had had access to those benefits and so on and so on. So affirmative action, in quotes, is nothing new. It had been practiced on behalf of white people. I mean, places like Harvard,
but people have only noticed it when it's been used.
Well, that brings me to the second book.
These past advances.
Indeed, that brings me to the second book, which is by the sociologist John David Scrintney, who teaches at the University of California, San Diego. Scrintney's book is called "The Ironies of Affirmative Action," and in it, he points out that you had veterans' preferences long before you had racial affirmative action.
Right.
And no one ever raised any of these arguments that you're raising about racial affirmative action. Okay? He says, if somebody puts a placard out in front of the store that says Smith and Son, and you walk in and you find a 30-something behind the counter and you reckon that, well, that's probably the son, not Smith, you don't stop to wonder whether or not they're qualified because of the nepotism to be in the position of running the store. You more or less assume it's a good thing. In other words, none of these cases are meant to be identical to racial affirmative action, but they're just meant to say that there's something additional that goes on when people bring these arguments to discredit racial affirmative action. And Scrintney argues it has to do with race, not with affirmative action. It's because it's blacks who are getting the benefit that you begin to think about whether or not that thumb on the scale really was some fundamental undermining of meritocracy and so on.
Yeah, I mean, it seems like we're converging on this idea that, look, this is one kind of program among many that can ensure the sort of workforce or the sort of student body that we'd like to see, and that fits into the diversity argument, and I think it stays away from the specific idea of remedying past injustices, or what some people might think of as a remediation or even a reparations kind of argument. There's a third sort of argument, though, that I want to push forward because I think it really relates to what you say in the book about the stigma argument and kind of tee it up and see what we have to say about it. In the Seattle case, which is about what Seattle regards as an integration program or what might be called an insurance program against desegregation, the Supreme Court strikes down this in high school in a program designed to ensure in admissions to high school that there is racial diversity, strikes it down. They consider something like the argument that we've been talking about, the idea that there has to be an equivalent of desegregation that happens in the South in the North as well. But as I remember it, Chief Justice Roberts, in his opinion, rejects the analogy between rectifying segregation in the South and the idea that racial injustice in the Northwest, in this case Seattle, has to be rectified in a similar sort of way. And he seems, anyway, in the opinion, to narrow the desegregation argument to instances of actual legal segregation in the past that were intentionally done by force of law. So what is it that we have to say to that? I mean, imagine that again, somebody trying to co-opt your argument says, look, I recognize that there is a history of slavery and a history of legal segregation, but when it comes to that argument about desegregation or undoing the stigma, we should just look to the legal instances of this where it actually happened, for instance, in the southern United States in the legal system of segregation. And it's just a disanalogy to think that a similar sort of thing is happening in Providence, Rhode Island, where we are, or in Seattle, where there was no legal history of segregation. What kinds of things could we say to that sort of argument, or what might you say, drawing on the book?
Well, I'm not necessarily against that argument. I don't know that it's wrong. It sounds to me like a limiting principle in which one wants to say a vague and sort of generic reference to a kind of atmospheric racism doesn't rise to the level of legitimating what is an extraordinary, what Justice Roberts and others will regard as an extraordinary departure from the equal protection requirements of the 14th Amendment. If I understand the legal terrain here, I'm gathering that all of this is about whether or not there's a compelling state interest which is necessary to legitimate the extraordinary departure from what otherwise should be a colorblind or racial
and in that case, he
neutral.
seems to say rectifying historical segregation that actually is
legal segregation. That would be legal, but
legal segregation, but not
making a better society
no
according to some sociologist's theory about what the balances of races in the school ought to be is not a compelling interest. And maybe that's right. I mean,
I think we're going to depart from each other because, I mean, to me, what it seems to say is that we're going to privilege desegregation, and we're going to care about it in instances where it was most pronounced, but we're going to ignore it when it's more subtle. I mean, it's not I just don't think it's the case in the North that there was no segregation. First of all, there was, I mean, it's often ignored, but there was slavery in Rhode Island, for instance, and so you have this history. You also have a history of segregation by housing, and to the extent that historically, anyway, school districts were drawn by housing differences. To me, the fact that there wasn't intentional or legalistic segregation in the schools doesn't take away from the fact that I'll be modest, a huge portion of the North, there was a more subtle form of segregation that was done by housing or that was done by, sometimes not so subtle. I mean, there were, I was talking to my mother about for Rockaway, where there was an area of the Rockaways that excluded people explicitly if they were Jews with a sign. So to me, anyway, to limit the desegregation argument and the rectification of past racism in the United States, and what was really, differences drawn sometimes explicitly and sometimes more subtly by race to the southern United States, I don't know, to me it risks ignoring northern racism and the history of it and the history of the responsibility in the North for institutionalized stigma.
Well, the distinction wasn't.
Do you want to resist that?
Excuse me, Corey. No, I don't want to argue with you about it. I don't hold the view that I express with particular conviction. I just wanted to say the distinction is not between North and South. It's between de jure and de facto, isn't it?
Right. That's right.
De jure being that there was legally explicit mistreatment of the African Americans, and de facto being that the forces at work through various institutions in subtle and not so subtle ways work to the disadvantage of African Americans.
That's right. That is the distinction.
So anyway,
I mean, to me though, I guess that's what I'm asking. I mean, why should it matter if the result is the same and the barriers sometimes are more invisible? To me, it still is segregation. I mean, there were de jure instances of segregation in the North, too, that took place, for instance, in more subtle ways through housing covenants that prohibited you from, they were struck down eventually by the court, rightly, but that prevented you from selling to an African-American family. So the fact that it was done through housing or through the private law of property rather than through explicitly public law, I guess, I don't know, I'm on my hobby horse now. I think that it was really an overreach by the court to try to limit the rectification argument to de jure instances of racial discrimination.
But I think there's a problem here, Corey. I don't know how, if we go down this road, we know where to stop. Because, there's a lot of racial discrimination in the private sphere.
That's true.
People choose their business partners, partly based on a comfort factor that undoubtedly involves, at some level, nepotism or within family, within ethnic group, religious affiliation. People choose their mates, their intimate lives. They make the most important contract that they're going to make in their life when they marry, and they discriminate by race with a vengeance when they do that. And many other examples that we could give of friendship networks and associations of a variety of kinds that are consequential for social outcomes. It's a part of what social capital is. It's how you're positioned and your links to other people when resources that are critical for human development are distributed in the population in part based on these linkages. And if you're poorly positioned relative to others in terms of your connections, you're definitely disadvantaged. You don't hear about the new job as quickly. You don't get the same degree of opportunity. You're disadvantaged. But you can't build law to rectify that kind of inequality, it would seem to me, without somehow questioning the legitimacy of the autonomy on which people act when they make these racially discriminatory choices about their intimate lives.
Yeah.
So there's,
well, I mean, this is a great discussion and a robust one, because I really am on the other side there. I think precisely for the social capital reasons that this is this is a matter of whether one can advance in society, whether we can overcome the historical stigma that we've been talking about, both de jure but also de facto, depends on not drawing the line in the most narrow way. I mean, for the Supreme Court, the most narrow way to draw the line has been in the equal protection jurisprudence is by saying that, look, it's only when the state acts that these concerns about equal protection are triggered. But to me, that's just too thin a way of going about attacking the sorts of discrimination that we've been talking about. So think of the 1964 Civil Rights Act, which is not an equal protection. The hook there for its legitimacy is not the Equal Protection Clause, it's the Commerce Clause. But it's about equality, the Civil Rights Act of 1964, and it says you can't discriminate in hotels and restaurants, which are part of the private economy. But I think that's just the first step of where the state, I think, has to start. Maybe not always directly regulating, in that case directly regulating, but caring about the sorts of discrimination that go on in the so-called private sphere.
I want to be clear.
I mean, as you know, too, I think civil society, maybe not through bans, but at least through tax incentives, for instance, we should structure civil society with incentives to rectify some of the stigma that we're talking about.
Well, first of all, I want to be clear. I do think that the Civil Rights Act of 1964 was constitutional. I think it was constitutional, and I think it was good policy. I'm not saying that all efforts to regulate private intercourse in the interest of equal opportunity across racial lines are wrong. I'm just saying that restaurants and hotels are about as far as you can go, and it's not nearly far enough to create genuine equality of opportunity.
I see.
Okay.
Right.
Family interactions, who you marry and cohabitate with, and so forth and so on, is nowhere near where the state should be going on behalf of this egalitarian project, and yet those things remain, really quite important. So,
as you suggest, if there was a state regulation that said to people that you have to, be colorblind or not discriminatory in choosing your future marriage mate, that just, I think, strikes all of us as has got to be a mistake. So there's got to be some in between. We both agree, and I think we might disagree about where it is, between the idea that it's only the state that can't distinguish based on race and this worry that it would be the family.
Go ahead.
I was going to ask you about another case.
Okay.
To get the two books, I guess. I mean, last time we talked, that you interviewed me about my book. We've been talking so far about the idea of racial stigma.
Right.
What do you think about? There's the Bob Jones case, in which the IRS denies tax subsidy 501c3 status to a private university that allows blacks in, but discriminates about
interracial dating, wasn't it?
Yeah, interracial dating, no membership in the NAACP, no advocacy of the right to interracial marriage.
What did I think about whether or not...
Is that a place where, because of the social capital kind of concerns and the argument about, certainly the stigma argument there when it comes to interracial dating, I would think, plays a role. So is that the sort of thing that you'd like to see, that you think the IRS was right in doing, is denying the favorable tax status to Bob Jones?
Yes, I say this without being intimately familiar with what the legal arguments would be around the criterion that I assume it's the Internal Revenue Service and the Treasury Department can use to extend or deny tax-exempt status. I say it without having the expertise. The policy of Bob Jones University, as I understand it, was noxious to me, and not the kind of message that I believe ought to be endorsed by the state. So to the extent that this is a charity that is getting the protections under the tax law of allowing people's contributions to it to be deducted from their taxes, it's being, in effect, subsidized by the tax law. And this is in very much a Brettschneider-esque spirit. and that the views that they take, which they're perfectly entitled to, are nevertheless inconsistent with values that I think my government ought to be affirming in its policy, if they have the legal discretion, which is the question I don't know the answer to deny them the tax exemption under the law as it stands, then I should hope they would use that discretion in order to send the message that,
we're in heated agreement.
We exactly. I learned everything I know about the subject from one of the political scientists who teaches here at Brown named Brettschneider.
I wanted to try to tie together the two threads of our conversation by asking you to respond from your current, I would say, evolved position, I guess. I mean, I'm, as I said, in heated agreement with a lot of what you've said today about your latter views, but to try to get you to engage, especially to return to the theme of the court, with the earlier Glenn Loury. So in the 80s, my understanding, and I read some of the transcript, that you were invited to be part of a discussion that included Justice Scalia and other prominent members of the, I don't remember if he was...
this was the D.C. Circuit Court's judicial conference.
He was on the circuit court.
At that time, he was Judge Scalia, that's right. I think it was 86.
86, okay.
Yeah.
And you were brought in, as I understand it, as an opponent at the time of affirmative action, and you were debating people like Lawrence Tribe in front of this conference.
Right.
So what would you have to say, either defending or responding to the Glenn Loury of 1987 about what's virtually the same topic that the court is now taking up in the Fisher case of whether or not the Equal Protection Clause is consistent with some variety of affirmative action programs?
Yeah, I would say, I guess, that that I understood the policy concerns that the Glenn Loury of 1986 was raising about affirmative action and about some of the arguments that were made on its behalf. I mean, Professor Tribe, Lawrence Tribe, the distinguished constitutional lawyer at Harvard at that time, this is now 26 years ago, it's a long time, was saying, in effect, that, Harvard Law wouldn't have had any African Americans if they hadn't engaged in affirmative action. And I was taking umbrage, I was saying, are you telling me that a Randall Kennedy or Christopher Edley or Lonnie Guinier, she wasn't at Harvard at that time.
How about Barack Obama? What year was he?
He was a student. He was a law review.
In the late 80s, right?
Yeah, he would have been there around in that time. Are you telling me that these guys are not really qualified? I mean, are you saying that you had to lower your standards? So come on, stop talking about people like that. So I would take in that kind of a view. What I would say to this guy, though, is that, well, Glenn, the question of whether it's constitutional is not a policy question, man. It's a legal question. And if you decided negatively here, you're ruling out a whole bunch of stuff. Okay, and not only for African Americans, you're tying the state's hands in particular ways. And do you really want to do that? And, the Glenn of that year might have given an argument about why he wanted to. The Glenn of this year doesn't find that argument to be particularly compelling. But the other thing that I would have said, that I might say to the old guy...
Do you think you were just confused about that, or that you were just harder in your opposition substantively than led you to that?
I think I was substantively hardened in my opposition in that. And in fact, some people, my friend Tom Schelling, the great economist who was my colleague in those years at Harvard, used to say to me all the time, he says, Glenn, whatever your feelings about affirmative action for blacks, don't let that, completely, in other words, you can separate the principled issue of is it or is it not constitutionally permissible from the prudential issue of is it or is it not a good thing to be done in this way, in this place, at this time. And he urged me to think of those terms, and I think I would have urged the old Glenn the same. But the other thing I want to say here is I would accede something to the old Glenn. I'd say, you used to say that affirmative action was not the solution to the problems of racial inequality in the country because it largely only benefited a small fraction of the African American population who were already pretty well set to be able to participate in the society, and it didn't address the deeper issues that drive racial inequality over time. And moreover, it was politically costly because it creates a fight that might really impede the formation of broad-based, class-based coalitions that could be constructed to do so forth and so on.
So there is a cost, you think?
Yeah, there's a cost. Absolutely, there's a cost. And, I think at the end of the day, if the Supreme Court strikes down racial affirmative action, in this case, Fisher versus the University of Texas, it will be a blip on the screen and almost a kind of anticlimactic thing. I mean, affirmative action is not a principal instrument through which we're going to address, and then you can just start ticking out the overrepresentation of African Americans on food stamps, the high number of black men who are in prisons, the disproportionate number of African Americans who have poor health, because they don't have access to health care, the segregation of our cities, the horrible condition of education for the least advantaged people, such as a city like Providence. You don't dare to send your kids to the public schools, but there are a lot of people who don't have any choice. Not you personally, Corey. All of those problems that you can tick off, affirmative action doesn't begin to reach them. And how much energy, how much ink has been spent.
That does sound like a consistent thread over time that you, it seems to me that I've seen this in a variety of writings over time where, regardless of your position, the old versus the new, you have a worry about the agenda in regard to issues that relate to race being entirely sucked up by this specific debate, and you want to see a broader agenda regardless of what and so maybe your concession is to the old Glenn too, that look, there are these other things that matter, and if we lose this one, at least we can maybe go on to those. I mean, the worry of, again though, as you say, is of cutting off possible solutions and of limiting experiments in how to do this and how not to do it. Let me ask you about another related argument to the themes that we're talking about.
Okay.
And I don't know if the old Glenn wants to respond or the new Glenn, but they're both invited, and it seems to me actually they both would, especially given what you just said, have something to say about it. And this is an argument that I was surprised, but it really dominated this panel that I attended on affirmative action. It's a very specific policy argument as opposed to an originalist argument, for instance, about the Equal Protection Clause. That was made by a member of the Commission on Civil Rights, who also teaches at the University of San Diego Law School, Gail, I think she pronounces her name Herut. Sorry, I'm probably getting that wrong.
I don't know.
But anyway, she references, and again, I'm not going to quote her, but I want to try to give the gist of the argument, what's sometimes called the racial mismatch argument.
Yeah.
And I guess, I'll admit before I say it that this is not something that I find convincing. It's an argument about the mismatch that's created between, this is the proponents of the mismatch argument claim, and again, not my view, that there's a mismatch between the kinds of schools that are now accepting, specifically accepting minorities, and the schools that they would do best in. So the argument is, look, if elite schools are admitting more minorities than they would otherwise, they're not doing as well in the school, they're not having as much success in the long term, and then they would have done better if they would have gone to schools that are, I guess, lesser in terms of the official rankings.
Right.
I don't know. I mean, having attended a lot of these supposedly elite schools, it seems to me that sometimes, and I'm confessing something here and maybe too much, that it's not clear that they're harder. That's one concern anyway that I had about it.
I'm familiar with the argument. A guy called Richard Sander at the UCLA Law School is a big proponent of this argument. He and Stuart Taylor. Stuart Taylor is a lawyer in Washington, D.C., and a writer, a legal journalist, have a book out called Mismatch.
Yes.
In which they,
he was also on the panel, I should have mentioned, Stuart Taylor.
In which they systematically review the evidence on this argument. And there is evidence, for example, from legal education to suggest that the net effect of affirmative action in law school admissions is to bump up the quality of the law school to which the typical African-American legal student goes from one that would have been better suited to his or her prior preparation, less elite, to one that is more elite than that there's a kind of musical chairs thing that goes on.
Right,
the argument is that most African Americans who end up going to law school under affirmative action would have ended up going to law school without affirmative action, but they would have been a couple of notches down the pecking order of quality of law schools, perhaps, in so doing. And they argued this would not have been a bad thing, it would have been a good thing, because when you're at the 20th percentile of the ability distribution in your class, you don't get as much out of the education as if you're at the 50th percentile of the ability distribution in your class. The professor...
But what does he say about the fact that Yale Law School has no grades, they have honors, I guess, but there's certainly no class rank. Stanford Law School, which I attended, now has no grades, and as far as I know, can't have class rank if there are no grades, and there are other elite.
Well, the proof of the pudding.
So why is it that they do? I don't even understand how the argument works.
Well, let me tell you how the argument works, which is that the class has to be taught in a particular way.
Right.
Okay, the professor has to pitch it somehow.
Right.
So much time has to be spent explaining stuff that people may come to grasp in different periods of time.
I don't know. Do you buy any of this?
Well, I say it's an empirical question, Corey.
Right,
It's not whether I buy it sitting here in my office.
Right.
It's
No,
whether
I'm
the
asking you
evidence
your
is
economic
consistent
hat.
with it. And what I was trying to tell you was that in legal education, they're beginning to amass evidence that is at least broadly consistent with the thesis. What I want to go on to say is that I don't see this. I mean, this is a point now about what are the effects of affirmative action when it's practiced within a system in which you have unequally ranked institutions, and in which one of the consequences of affirmative action will be to alter the distribution of minority students along the hierarchy of these institutions. And the claim is that one of those effects is to lead to mismatch, that is, minority students who benefit from affirmative action kicked up the queue, the hierarchy of institutions, and that might not be in their interest because they may not be well placed. Now, when you have, as the data show in law school admissions, the typical African-American student at an elite law school finishing, you say there's no grades at Stanford? I didn't know that. I don't know how then you're going to know the class rank of somebody. So these are data that are drawn from the period when there were grades. But they also use did you pass the bar on the first time or the second time? And did you drop out before graduation? Dropout rates are very low at the most elite schools and so on. There are other criteria for assessment. This is controversial. The evidence is being debated back and forth by people as to whether or not it shows it. All I'm trying to say is it's an effect that I think is worth taking seriously and looking into. But it would not rise to the level of constitutional prohibition.
No, exactly.
It's more of a prudential assessment of whether the policy is working well or poorly.
Right.
Okay.
I mean, it sounds like it's making the mistake, the people who are relying on this, at least, and thinking that Fisher should be decided along these grounds, are making the mistake that you were attributing to your former self, which is confusing the policy argument about affirmative action with the constitutional question of whether it should be banned as inconsistent with the Equal Protection Clause.
Indeed.
I mean, I would say, too, though, on the policy, I mean, and I defer to you on matters of large empirical studies. I know that this is your expertise, it's not mine. But there do seem to me to be some mistakes, I guess, in the assumptions, namely the idea that elite law schools are quote unquote harder than other law schools, or that it's just harder to compete in these schools. I mean, the first response to that is that it relies on the idea of a curve, I guess. The second is that I don't know that there's that much difference in terms of the curricula that you get at these different places, or that the ability of African Americans or anyone else to learn at elite law schools is is harder than at other schools. I mean, if you think about what a lot of elite universities do, and I'll mention Brown actually as an example of this, is in some ways they tamp down on the competition in order to open up a space for learning. That was the idea here, at least of the new curriculum, is to create more community and less competition. There might be objections to that, but the idea of not having grades, for instance, in the elite law schools is to really open up the possibility of exploring and learning and giving these kind of luxuries. The other point, I guess, just thinking about your work, because it's on my mind, is that the amount of social capital that one amasses from coming to one of these schools, I think in the long run is really going to help in terms of your career prospects, whether you're a lawyer who passes the bar or whether you do something else, because the value of the degree is often in the name of the school and of the credential.
Okay, let me just say a couple of things about that, and then I have to conclude.
Yeah, because I'm relying on your work here.
Well, no, what I want to say is you can take grades away, but you're not going to take assessments being made about who's smart and who's not, about who's clever, about who's good, about who's a crackerjack, about who's a star.
Right.
Okay, I predict that if you don't have objective measures of ability, of performance, of promise, which are arrived at through some kind of systematic assessment, you will replace that with non-transparent, not accountable, sets of surmises and subjective judgments and superstitions and stereotypes about who's good. I predict that elite law firms are still going to want to hire, quote, the best students, close quote, from elite law schools, that people who get associates to do their contracts or whatever it is, they're still looking for a certain type who's a certain kind of legal writer, who has a certain kind of mind and all of that, and that those judgments are going to end up being made at the end of the day in any case. I predict that amongst the students who attend these schools that you described, which are trying to cultivate a kind of community of learning that's not competitive, there will still be lines drawn. Yeah. There's still going to be a pecking order that the professors, when they write letters of recommendation, will still say so-and-so is the best or the second best, that the clerkships and the key posts at the best law firms are still going to go to kids who have a certain kind of background, who talk the talk and walk the walk in a particular way, so forth and so on. So,
I mean, it does, I guess, of course there'll always be distinctions made between people, but the system that doesn't have a formalized system of grades or ranking opens up possibilities of making connections with professors, working on papers that get noted, and then getting that recommendation. I mean, the reason I think, too, why the social capital argument, especially in law schools, is so important is I watched on C-SPAN a Judiciary Committee asking a couple of Supreme Court justices, one of which I believe was Clarence Thomas, whether they would hire law clerks outside the very elite law schools. And they were making the argument that they wouldn't, not because there aren't good students at those places, but just because the networks of trust in the elite law schools are so powerful that the chance of making a mistake in a law clerk and getting a bad person are very low when it comes to the elite law schools. Well, what that suggests about the mismatch argument to me is, if you start confining, you start worrying about that argument too much and start arguing that there shouldn't be as much recruitment of minorities at these elite law schools, that's going to impact the glass ceiling question in the end, because they won't be able to get clerkships then that they might otherwise have been able to get. And ultimately, clerkships too are a proxy for Supreme Court nominations. And in the long run, when it comes to who's going to occupy the highest offices, it's essential, I think, that these, I guess, quote-unquote elite schools have a massive amount of diversity. Most of them are private schools, so they won't be directly impacted by what happens in Fisher. But my hope is that they will resist efforts to get rid of affirmative action because of the mismatch argument or otherwise.
Thank you, Corey, for coming on the Glenn Show and doing the job of interviewing.
No, you forgot the Corey Show.
Yeah. Okay. As I say, in your dreams. Nice talking with you, Corey. You're welcome. Thanks again. Take care.
A pleasure. Thank you, Glenn.
Bye.